Okay, I'd like to call this zoning meeting of the Zoning Hearing Board to order, being that it is 7 o'clock. This is a meeting of the Huntington Township Zoning Hearing Board. We have one hearing scheduled for this evening. We do have an attendance sheet being circulated. Please make sure that if you are in attendance that you put your name and your address on that sheet and sign in. I'd also ask, as a matter of courtesy, if you could just turn your cell phones off so we are not interrupted. If you just silence them, that would be appreciated. I'd like to begin the meeting this evening with the Pledge of Allegiance. In lieu of a roll call, I'd like to introduce the Zoning Hearing Board members. We have myself, I am David Reinecker, Chairman of the Zoning Hearing Board. We have Tom Hart, he is Vice Chairman of the Board. And we have Doug Spielman, who is the Secretary of the Board. As such, we do have quorum established with all three of our members being in attendance. I'd also like to introduce our solicitor, Matt Teeter, of Teeter Law Office in Gettysburg, as well as Deb Zepp, who is our stenographer this evening, and Gus Friedenvalls, who is the Zoning Code Enforcement Officer for Huntington Township. We will now go into introduction of the case. And Matt?
I have a few things to go through here. We have one case this evening, as Dave mentioned. This is the application of My Three Girls LLC.
Matt, I'm gonna interrupt you. I missed something on the first page. This is our first meeting of the year of 2024, being that we're already into November. And as such, we are asked to organize for purposes of order within the township. So I would open the floor for nominations for officers, chairman, vice chairman, and secretary.
I'd like to make a motion to nominate Mr. David Reinecker as chair, myself, Thomas Hart, as vice chair, and Doug Spielman as secretary.
I second it.
Okay, we have a motion and a second to organize as such. Is there any discussion to the motion? Hearing none. All those in favor of the motion signify by saying aye.
Aye.
Aye. Opposed? So moved. No, Matt.
Okay.
Thank you.
Our one hearing tonight is the application of My Three Girls LLC. It involves property known as 255 White Church Road, York Springs, PA 17374. This property is in the township's commercial industrial zoning district. The applicant is requesting a variance from sections 27-1141.3 and 27-1141.4 of the zoning ordinance, which are the setback, front yard and side yard setback requirements for property with the proposed use of manufacturing here, which is what the proposed use of the applicant is. I want to confirm that the hearing has been properly advertised. Gus, do you have that information?
You got it in your packet
Oh,
there.
yeah. Okay.
A notarized statement and with a picture of the ad that was run. The property was posted And there's a copy of that, and the letters were sent to the adjoining landowners, and
Okay. I'll just go through that really quickly. We have the proof of publication from the Gettysburg Times indicating that this was, notice of this hearing was published on October 23rd and October 30th. We have a notice that was posted on the property. That was at least 7 days prior to this hearing. We have the you mentioned you sent out notices to the adjoining landowners and to the applicants, I guess.
Correct.
The applicants here today. Okay.
Gus, have you had any communication with the adjoining landowners?
other than Tom Strife that I run into all the time, he's the only one.
Are there any of the adjoining landowners in attendance this evening? Okay.
Doug Shield, White Church Road, 345.
There he's
Joining
one.
in the rear.
What's that?
Joining in the rear of the property.
Okay.
I want to briefly go through some procedures for the zoning hearing. This is just to describe how the hearing will be conducted. The zoning hearing board is somewhat like a court of law, exists to ensure the equitable application and administration of the zoning ordinance enacted by the Township Board of Supervisors to any one specific property. The board cannot make or modify the zoning ordinance. It does not have a legislative function. This is a hearing, not a meeting. The applicant's witnesses, and any parties in interest and their witnesses will be testifying under oath, and a verbatim transcript is being made here by our stenographer, Deb Zepp. For this matter, the applicant will be heard first. This is an application for a variance. For a variance, the applicant must prove, well, usually for a variance, there are some other types of variances, but the basic variance or usual variance involves proving with sufficient evidence on the record, enabling the board to make findings that the zoning ordinance inflicts unnecessary hardship on the applicant. The board may grant a variance if the following 5 criteria are met: that the unnecessary hardship is due to the unique physical circumstances of the property. In other words, the property is different from other properties in the district. That because of those unique physical circumstances, there is no possibility that the property can be developed in strict conformity with the zoning ordinance. That the unnecessary hardship was not created by the applicant. That the variance will not alter the essential character of the neighborhood or district. And the variance represents the least modification possible. If the board approves the variance request, it is permitted to attach reasonable conditions as necessary to ensure compliance with the ordinance. It will assist the board in its deliberations if the applicant is clear to address each of the above items in his or her testimony, or if there is another theory of variance that we're proceeding under, please identify that as part of your case. Following the applicant and the applicant's witnesses, any interested party in support of or in opposition to the application will be heard. Parties in interest are those individuals who can demonstrate an immediate and direct interest in the matter that is before the board. That's generally determined on proximity to the property in question. You know, neighboring properties are usually parties in interest if they want to be, but they could be farther away too and still have an interest in the outcome of the hearing. Parties in interest have the right to question the applicant during the proceedings, as on cross-examination, and they have the right to present their own evidence and to appeal the decision of the board to the Adams County Court of Common Pleas. It is up to the board to determine who may be a party in interest. In addition, the board may provide time for other community members to comment on the application. However, this is a hearing, and public comments are not testimony and will not be taken into account by the board in making its decision. After I'm done here, we'll ask if anyone wants to be designated as a party in interest, and we'll get your information. Whenever you're speaking, we ask that you stand, state your name, address, and make your statement or present your testimony. When you speak loudly and distinctly so that a stenographer can hear your comments and keep the record. Address only the issues at hand, namely the specific relief being sought by the applicant. Comments not connected to this specific zoning relief being sought are irrelevant to the board's deliberation, cannot be considered. We're somewhat informal as to evidence and process, but it is a hearing, and the chair, my assistant, will maintain order to ensure the board hears all testimony that is relevant to the application and will control the order of the presentations. The other thing I want to make sure we understand is that everybody who is a party or a witness or wants to speak will have an opportunity to do so. We all need to remember that we can't speak over one another because it makes it harder to keep the record. So let's speak one at a time. And we'll remind you of that if necessary. I'm sure Deb will as well if it gets to the point where we're talking over one another. So as I said, parties in interest. Does anybody want to be considered a party in this matter? That is, you would receive a copy of the decision, you would present your own testimony and witnesses if you'd like, you could cross-examine the applicant and our zoning officer. You can provide your own testimony under oath. Does anybody want to be considered a party in interest? Okay. And I did hear you say your name. You said your name. What was it? Doug?
Doug Shiel.
Shiel?
Yeah, Shiel.
Could you fill this out for me? It's an entry of appearance form.
Yeah.
Don't worry about the top. I'll fill that in with the application information. But if you can put your name and information up there, and then and the
You can sit there.
blank lines below it, there's just an area you can just state that you are you own property in the vicinity of the subject property. Okay. Once you've filled that out, we'll go ahead and swear witnesses in. It would typically be the applicant and any applicant's witnesses. Gus typically be considered a party and a witness. He could be sworn in, and then also Mr. Shield.
Mm-hmm.
All right, I'm going to have Deb swear everybody in. If you could stand up and raise your right hand, you're going to be presenting testimony.
Do you swear and or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
All right. We'll have the applicant go first here. Could you each introduce yourselves?
Jeff Fortuna. And Lon Lobaugh.
That is Jeff Fortuna.
Yes.
F-O-R.
Fortuna.
Okay. And you're from?
Dillsburg.
Okay. Are you one of the owners of the LLC that's the applicant here?
I am not. I'm part of LCDM.
Okay. You, sir?
And I'm Lon Lobaugh, and I'm part of My Three Girls, but it's My Three Girls are the owners.
What did you say? It's Ron?
Len.
Len.
Len,
Len.
L-E-N.
I'm sorry, I'm not hearing.
L-O-B-A-U.
Okay, which one of you gentlemen would like to go first?
Second?
Yeah, sure. Yes. Good evening. Thank you, guys. Just a little bit of background on the company. To start off, LCDM is a designer, manufacturer of grain handling products. We've been in Dillsburg now for 10 years. We're a sister company to TAM Systems, who's been around for over 40 years. They are millwright contractor that designs, builds, and services grain and feed mill systems. And currently, we are all at the same same location in Dillsburg, and we're looking to relocate just because of our growth, and came across this property and felt like it was a good fit for us. Anything you want to add?
I guess we have to specifically address the requests on the setbacks. We anticipate, we have a contract on this piece of property with the current owner that settles next Thursday. A condition of our contract is that these setback issues be addressed through the zoning hearing board. We did not build this building. We are acquiring this building. We can't speak to what the owner did, but based on an engineering review by our engineering, we show that we are within the side yard setback of 50 feet. We are also within, we think, the 100-foot setback of the street line, which we're not sure the term where the street line is, but for our security, for the purpose, we would like to have a variance on those two setbacks based on the existing location of that building. So it's taken care of as part of the purchase of that property for LCDM.
All right, anything else? Should we read this?
Yeah, go ahead.
We believe that the variance should be granted because the manufacturing use of the site was recently granted by the Township Board of Supervisors, and the minor relief requested to use the existing building will not impact the adjacent property owners. The proposed manufacturing use will comply with township ordinances relative to manufacturing facilities and meet all requirements contained within section 27-1141 of the township zoning ordinances. The proposed development will be constructed and operated per the requirements contained within the township zoning ordinances and will provide the required buffer and screenings required and restrict the impacts of noise, traffic, and other operations which would affect adjacent properties.
Mr. Fortuna or Mr. Lavelle, could you describe a little bit more of what the manufacturing process in this building would look like in terms of traffic, employees, noise, light?
Sure. So right now we have 10 employees, and as far as what the parts look like, they, for the most part, fit on a 4x4 skid pallet. And we ship those, LTL, which is a van trailer, or a flatbed truck. I would say on average in a week's time, we would see 5 LTL trucks in a week and 1, possibly 2 flatbed trucks a week.
So that's total, that's not per day.
Correct. That's
That's
total for the
total-
week, and
total for the
that
week.
would be tops.
Okay,
Sometimes you're busier than others,
sure.
but that gives you a good average of truck traffic. Like I said, 10 employees. As
And
far as,
these 10 employees would be located at this facility?
correct.
Okay.
Not initially.
No,
We're not gonna have offices there until we go through the process of building offices.
Okay.
So what would it be, 6?
Yeah, 5 to
At
6.
Yeah.
5 to 10.
Yeah, correct. Yep.
Okay.
As far as noise, I mean, typically it's just your common hand tools, some grinders. Nothing, that I would think makes a lot of noise.
Normal business hours.
Yes,
Noise.
7 to 4 business hours. Very rarely, we'll be there after 4 o'clock. If we have to load a truck for some reason, the truck's late, we'll be there till maybe 5 o'clock, but 95% of the time it's going to be between the hours of 7
And that's
4.
Monday through Friday?
Correct.
Closed on the weekends?
Correct.
Okay.
Yes.
Any plans to expand from the 10 employees or whatever in the next 3 to 5 years?
We will need additional space. Right now, this will be manufacturing. There'll be no warehousing space here. We have a distribution center in Missouri, and we'll continue to store materials at our Dillsburg location, but we would be interested in expanding so we can inventory on this property along with the manufacturing.
Is there room for that expansion presently with this property?
Yes. Yeah, it's 29 acres. There's a big part of that's not really good functional land, but there's 8 or 9 acres on the front side and the street side that offers opportunities for expansion.
Okay.
In your verbal description of what you're seeking relief from, you mentioned both the 100 feet setback from the roadway as well as the 50 feet setback from a buffer from the side. But in your application, that 50 feet setback is lined out.
Well, they're within that setback. I measured it myself.
Okay.
So you do have 50 feet on the
On
side?
the buffer, you have that.
Okay.
So that's why it's lined out in the
No,
application.
Well, I think that was a mistake. But the 50 foot, there's a fence. And when I measured it, I measured from the building to that fence, and that's 50 feet exact. Now, is that fence the right line? I don't know that for 100% sure. But if it's off, it can't be off by much.
Okay. Did you measure the dimension from the roadway?
I did, but that was tougher to do. The roadway has a curve in it that you can see if you look at the topographical picture.
Yeah.
But as close as I can figure it, if it's short maybe 2-3 feet.
Okay. Thanks, Gus.
Gus, is that difficulty, you said, because of the difference between the cartway versus the right-of-way edge? Is that what?
Well, that's some of it. The road has a curve, not a big curve, but a slight curve, and where you come to it, and the ground is uneven. It isn't 100 feet. It's less than that. That's why we're asking for the variance. But I figured it's off by anywhere from 4.5 feet to 3 feet. That's as close as I could figure it.
Do we have any idea when this building was built?
Yes. It was built it's less than 20 years old. I got records. I issued the permit when it was built. It was built in the 2000s.
Okay.
It might be as new as 10 years.
2019.
Was it?
2019 or 2020.
All right.
Top of my head.
I would just say it's pretty recent. This was
Yes.
our last hearing. It was the subject of the last zoning hearing that we had.
Oh, okay.
Mm-hmm.
It had that baseball
Oh.
facility in it.
Mm.
So it's the same property. And
This is the same property.
Okay.
Just so getting back onto sort of the track of the order of things. Gus, do you have any questions of the applicant to ask? We'll give you some more time to speak after that, but any questions you'd like to ask them?
No, I think they've stated the situation.
Mr. Shield, do you have any questions of the applicants? Keeping in mind that you'll have the opportunity to testify on your own and present anything you want to present. This would just be questions about what they.
Yeah, specific to, you actually addressed a lot of my questions in your own testimony, so I don't have significant questions to add. But I would ask, have you either submitted to the township a land development plan for any of the construction that you would need to do to make the facility usable?
No.
Have you had any plans of that type evaluated by your independent engineer for developing feasibility on that property?
We've had a very simple concept
Okay.
completed. Obviously, until we own the property, we're not gonna make that. That's a substantial investment.
Catching on. Have you reviewed some of the other land development plans that were submitted to the township for a sense of the general developability of the property relative to your general concept?
You mean as far as what he was going to do? Or
Any of the other recent applicants, for that matter. I asked that question just from a due diligence perspective and a thoughtfulness perspective. If you haven't, it's okay, but I would suggest, as from a commentary standpoint, that you closely evaluate what other engineers have determined is feasible on the property to understand what your real footprint is. It may be larger or smaller than you're expecting, with greater or lesser limitations and expense. That's why I put that forward.
we recognize there's a large piece of that property that is not developable.
Okay.
There's wetlands, there's getting through the wetlands to get to some viable land. So we do recognize that. I worked through in 2010 a land development plan in this township for 4 acres I owned on Ridge Road. I am somewhat familiar with working with the township through a land development. We have not done any infiltration testing, things like that, so we don't know where those things lie. And until I own the property, I'm not gonna make much more of an investment in it.
Yeah.
It's been a challenging 6 months to get to where we are tonight.
Understood. Just, I make that comment from the standpoint of wanting any next owner of the property to succeed and to know the limitations of the property and or their wallet with respect to their aspirations. That's all. I just don't want people to get hurt. That's all I'm trying to do. So, with respect to the setback itself, it doesn't, whether or not we're plus or minus 4 or 5 feet doesn't impact me personally as a property owner significantly. From a procedural standpoint, I would, encourage the township and the solicitor to consider, the precedent under which properties are developed with differing intents and ensure that applicants are, when making development choices, are understanding some of those decisions with respect to setbacks and placements, and then also looking at the process for validating some of those footprints before the concrete dries, if you will. It's kind of done at that point, but that would make things a lot easier for developers, for current landowners, for transacting landowners, and future landowners to not have to come in here and have a conversation about 4 feet from the roadway on a funny curve, right? So just a little encouragement. That concludes my questioning at this time.
Okay, thank you. We appreciate your input and your questions.
Does the board have any more questions of the applicants?
I don't have any more.
No.
Gus, do you have any more details you want to fill in about this or thoughts on the application?
Well, I'd like to see this property used. I mean, the building sat there for the last couple of years. From what I know of their operation, I don't see it as an intensive industrial use of the property, I don't see it as being incompatible with the neighborhood and what is already there. Granted, there's several residential properties, but we have a mulch operation across the road, which so far has had very little impact on the area. And up the street, we have a sign company that is very similar to what they're doing here. And other than the people driving up and down the road, that's about the only impact we've had. Wouldn't you say?
Yes, traffic does increase with each of these developments over time. Light manufacturing tends to have a lighter impact. You know, folks in that position need to be good neighbors when you're co-locating with residential. It's not an industrial park yet, but being that as it may, I mean, that's an important part of avoiding conflict early on and continuously through use of properties. So.
We're very familiar with dealing with residential neighbors. Our existing building is the only commercial building. And we have residential neighbors all around us. So we're very familiar with being a good neighbor.
Understood.
That's all I got.
I just want to clarify for my own edification here, since this is a dimensional variance issue, so does you feel that the building is 50 feet from the property line, or pretty darn close to it?
Yep.
Is that different from what your engineer or something has said, or there?
Without having a survey, we can't answer that. And again, comes back to until I own it. A survey would be part of a land development we would do. I think the reason we were requesting it is if we find out as we survey it, we are there. Now we've got to deal with that, another zoning hearing board again, as part of our land development to get a variance, because now the survey shows we are within that setback.
So the question really is the fence on the line, is the fence accurate with the surveying boundary?
I spoke to the neighbor about that, and
Okay.
he basically said the fence is the line.
He said that the fence, he thinks, according to him, the fence is the
Well,
line.
let's,
We're going to have to assume, for this hearing's sake, that the fence is the line, and that Gus has been out and measured it, and the building is 50 feet from the fence. So we're going to have to accept those parameters as true for the sake of this. And
So
move
that
forward.
means if we start to do our land development and find out, we gotta go through another zoning hearing, correct?
Oh, I will give some advice to the zoning hearing board about that. I can speak to that a little bit here on the record, and I'm not saying that the board will or won't grant a variance on this basis, but there is certainly something called a de minimis variance, and so the board could decide that it is 50 feet off the line or within a couple of feet, and decide that that's enough to say that the variance would be de minimis. And whether there's any parameters that would be assigned to that would be for the board to discuss. But based on your testimony and Gus's testimony, I think that the board can assume that it's 50 feet or pretty doggone close to it. And then Gus, I guess the other thing I wanted to ask again with the road to clarify, when you were measuring the 100 feet and saying it's within 3.5 or 3 to 4.5 feet, is that from the cartway or?
that's from the edge of the road.
Okay.
And the road's 18 feet wide. And they actually have property on the other side of the
From the
road.
road, it's 48.
It's
Yeah.
not a lot, but it's a little
So
bit.
is he comfortable with that number?
Okay.
This is 50 feet here.
So you'd say it's 3 to 4.5 feet from the roadway, and then in terms of the right-of-way line, it might be,
Okay, well then, I didn't.
or 3 to
So
4.5 feet, less than 100 feet
Right, exactly.
from the roadway, and then maybe, a few feet more if you were to go to the right-of-way line.
I'm sorry.
Go ahead.
I did not know that our engineer did do a layout, and he shows that where the front corner of the building is 2.21 feet within the side yard setback.
Okay.
2.21 feet. It's not square.
Part of the building is within the setback, but as,
The very front corner is 2.21 feet within the side yard setback
Okay.
So it's short, about 2 feet
on the side yard.
on the side, in the front
Yeah.
corner.
correct.
And the building doesn't run exactly
Does
parallel?
square with,
It's not square with.
it's not square with
property
the, with the
line.
property line.
Right. That's about what I came up with.
Does that have the front yard?
He uses center of the road.
The center road is 9 feet from the edge of the road.
So is that the center of the road? He's showing 25 feet, 50 and 50. And he's showing, he doesn't give us a dimension there.
Well, right here.
It's the same to the front.
It's that front
It's
corner.
that front corner towards the Heidlersburg end of it is actually, I can't tell you what it is. 10 to, is that 10.3
Yeah,
feet?
yeah.
10.3 feet at the front corner is what he's saying. The encroachment is on the end of the building towards the curb.
So 10 feet shy on the roadway.
Yeah,
So 10 feet closer to the roadway than it should be.
right.
Right, and if you look here, it's
It's the
maybe
way
the front 10 feet of the, I don't know, if you want to look at this, you can get you a better idea of what it looks like.
Yeah,
You
sure.
want to do it?
Just
Yeah.
see how that road turns there. He's actually got this line here where it kind of shows where it encroaches here.
It's
And
not
then
square on
right.
the
It's not square on the
sides.
front of the road.
Yeah.
And it's the same way on this front corner. He's showing 2.21 feet overlap into that side yard setback.
Yep, understood. Okay.
If you look here, he's got a note, it doesn't square with the, and he shows 2.21 overlap into the side yard setback here. And then because of the road, it actually shows that as it turns away, it picks up and this front corner is within the setback. Now that's the only note I see, 10.30 overlap. Excuse me. So I assume that's a 10-foot encroachment on that front corner.
Okay, it looks like that the plan does have the full right-of-way, and so that 100 feet, the 50 and the 50, the 100 feet from the right-of-way line, that's a 10-foot, give or take, encroachment just on that corner.
Front corner.
Well, and there was,
That right of way is showing at the side, at the edge of the road,
Yeah.
and they're showing a 25-foot road.
Well-
Even if the road is only 18 feet.
Yeah, well, the cartway itself is 18 feet wide.
Understand, but the right of way is,
Is the setback requirement in the ordinance from the cartway or the right of way?
just says setback,
It says 100-foot building setback.
does not say. It says from a street right of way line.
From the street right of way line.
we had some trouble with the definition, trying to figure out where the starting point was.
That's probably the improvement.
So that's from the edge.
I read that, if you look at the roadway here, I read that as being, because that goes, the dark line that's going to end the street is the property line.
That's the property line.
And the smaller, and that 25-foot line appears to me to go past that line to the center line of the road. So I think it's saying it's 25 feet. They're measuring 25 feet from the center line is the end of the right, is the edge of the right of way. And then they're measuring 100 feet off of that.
Yeah, 50 and 50 from
The
this
edge-
line.
Right, from 25.
From the right of way, the dedicated right of way, ROW line. And that is 25 feet from the center of the roadway.
I agree. That's the right of way line. It's 50 feet and then another 50. But the arrow, the arrow is inside the
Correct,
building.
it is inside the building.
So
Correct.
is the suggestion that you're a couple feet?
Right.
You have to draw a line to figure out how many feet.
Well, he's actually got that, I think that's his half line there.
Okay.
That angled line there, I
All
think
right.
is just kind of showing us.
That's his
rough-
indication.
Yeah, that's his indicator of the angle of what the corner is.
The maximum encroachment here is on that corner, and it goes up. I think that 10.3 or whatever that says is probably the maximum encroachment, and that looks like it
Right.
is pretty close the rest of the way. Either no encroachment over here or within
Yeah.
a foot or two.
So what's he showing?
That one's 2.2 over. So they don't have a measurement as to how far over this one is, but
Does not
it's some number of.
Well,
No,
he
he
has
does.
a 10.30
overlap.
overlap. So
Right.
I don't know if that's 10 feet at the
Yeah.
widest point or what it is there.
Is it the widest point in there? But yeah, so probably 10 foot at the widest
At
point.
the widest point.
Yeah.
At
I would
this point.
infer,
That's what I would say.
Yeah.
but
That's the most of the overlap is 10 foot, I would
Yeah.
assume.
and then the maximum overlap in the front corner is 2.
2.21.
according to his, according to the engineer.
Okay. Do you have another copy of this?
No, we can get you one tomorrow.
Can we keep this one?
Can we keep this one for now
Yeah, yeah,
and include it in our decision?
yeah.
Because I think that would be a little more fundamental for us.
Yeah, Chris. Okay.
We'd appreciate that. Thank you.
Let's go ahead, if you don't mind, let's go ahead and mark that as
do
applicant exhibit 1. We don't have any other exhibits, so we'll just call it exhibit 1. I'll do A1. And just for the record, A1 is a one-page plan from Hoover Engineering Services, Inc. It's zoning hearing board exhibit of 255 White Church Road, Huntington Township. And it looks like it was dated May 18, 2024. Do any of the board members have any other questions, follow up with any of the parties or witnesses?
Tom, Doug?
Nope.
And I have nothing.
Do you gentlemen have anything further based on this discussion?
Nothing more than to say we're on a deadline.
Understand. We're aware.
Mr. Shield, anything further that you'd like to present?
Again, my comment is it's the setback consideration itself right now is not a major concern for me one way or the other. The township should consider any potential safety or other reasons why that ordinance exists and those specific measures exist. and whether or not the degree to which the variance is requested impacts those safety or other concerns. But individually, I don't have a concern with what's been demonstrated here, other than that it occurred in the first place.
Right. I understand that. All right, Gus, anything you want to follow up?
No, that's it.
All right, generally, if the board wants to, we will adjourn into an executive decision. The board is permitted to deliberate in executive session and ask questions of legal counsel, solicitor, me, and then when we come back, we have further discussion and there may be a vote on a decision. So that's when we go back to that.
The first off.
Okay, we're off the record in executive session.
Well, they bought your information from somebody and then mishandled it.
Okay, let the record show that we are reconvened.
Okay. We're back from executive session. Board has not had an opportunity to deliberate and ask any questions legally of me that they might have. And at this point, is there anybody, or does anyone from the board want to make a motion on this application?
I'd like to make a motion that we grant the requested variances from section 27-1141.3 and section 27-1141.4 of the zoning ordinances on the basis that the encroachment of the existing building into the minimum front and side yard setbacks is de minimis.
I second that motion.
Okay, I have a motion and a second. Is there any discussion from the board concerning the motion?
None.
Okay, all those in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion is granted.
Just to elaborate a little bit, we will, the board will issue a written decision. We have 45 days to do so. I understand you have settlement next Thursday, and I cannot promise that we will have a written decision delivered to you, but you certainly have a verbal decision at this point on the record, and should be able to move forward. The written decision will have a little bit more information about those, what makes that, what makes this a de minimis variance, based on this exhibit and showing that on the side yard it's, between 2 and 3 feet, and in the front it looks like to be between 1 and at a maximum 10 point something feet at that corner, and given the circumstances and the reality of this property, that's a de minimis variance. Obviously, the board's decision is based on the evidence and testimony presented, and not apply to any further encroachment or development on the property, which is all still subject to township zoning ordinance and other ordinances. Any questions?
Okay, hearing no questions, I adjourn this hearing.
All right, we're adjourned.
Thank you.
Thank you.